Welcome to Middle Class Matters, Business News in English from Dr CMA Alagesan. Securities Exchange Board of India, SEBI issues a confirmatory order in respect of Subash Chandra, the chairman, and Punit Goenka, the managing director, in the matter of ZEE Entertainment Enterprises Limited. Part number 18 continued. 92. Fair investigation requires that all the relevant facts necessary for examination to arrive at the possible violations are, before the investigating authority. In the instant matter, it is stated by the entities that after the resignation of the independent directors, internal examination into the appropriation of fixed deposit has happened and steps have been taken and appropriate updation has been made to the shareholders on this issue. What is important to assess whether their internal examination has covered the entire facts of the issue or only selective aspects of the issue. In the board discussions dated October 17, 2019, as reflected by the minutes dated November 25, 2019, the issuance of LOC, which was the trigger for the appropriation of the fixed deposit in the first place, appears to have not been discussed at all. Thereby, again, the board was given selective information. The issue being highlighted before board was fixed deposit appropriation rather than the LOC issuance by entity number 1 without the board approval, triggering the appropriation of fixed deposit. In the corporate announcements dated October 17, 2019, the shareholders were again given the selective information. No information relating to LOC issuance by entity number 1 was disclosed to the shareholders. The issuance of LOC issuance without the approval of the board was not even covered in examination by Grant Thornton that was appointed for internal review for matters including related party transactions. Only in the annual report dated August 26, 2020, a reference of the LOC is made stating that it was issued by entity number 1 in his personal capacity. And as I found earlier, this could not have been the case. It is also noted that no objection was made during the discussion that Yes Bank had with leadership team of ZEE Limited before invoking the LOC. No complaint was made or litigation was filed against Yes Bank challenging the invocation of LOC if it was, as claimed, issued in entity number 1's personal capacity. The above only illustrates that selective information was shared with the board and the public, while effective steps have not been taken against entity number 1 for not taking approval or informing the board for giving a LOC that created encumbrance on the company's assets in his official capacity. It does not stand to reason as to why no effective step was taken against Yes Bank by ZEE Limited. If ZEE Limited believed that the LOC was issued in his personal capacity by entity number 1, all these facts and circumstances go on to show that the continuance of the entities can result in them adversely exercising their influence over relevant entities to misrepresent or selectively disclose facts so as to misdirect the course of the investigation. 93. In consideration of the above, I find that the urgency shown by SEBI in issuing the interim directions while the interim order was justified in the peculiar facts and circumstances involved in the matter. Assessing whether the restraint imposed on the entities needs to be continued. 94. In light of the above findings, I now proceed to examine the question whether the restraint imposed on the entities needs to be continued considering the following parameters: A. Prima facie case. B. Irreparable injury. C. Balance of convenience. Prima facie case 95. In view of what has been discussed herein above, I find that the entities have not been able to refute the observations regarding prima facie violation of the provisions of security laws contained in the interim order. In the foregoing paragraphs, I have determined that there exists a prima facie case against the entities that they were involved in design and execution of the scheme, whereby the 7 associate entities were benefited directly, with the ultimate benefit accruing to the members of the promoter family of ZEE Limited, including the entities, at the cost of the funds belonging to the public listed companies, that is ZEE Limited, and other listed companies mentioned in the interim order. I have already discussed at length the various facets of the prima facie case against the entities, and for the sake of brevity, I draw reference to the previous paragraphs of this order. Irreparable injury 96. From the viewpoint of the irreparable injury that is sought to be prevented by way of the continuance of the interim directions against the entities, it becomes important to once again refer to the imminent harm that may be caused if the restraint imposed while the interim order were to be revoked. As has been discussed in detail in earlier paragraphs, the conduct displayed by the entities exhibits that their interests are directly in conflict with the shareholders of ZEE Limited, since they have attempted to conceal the very fact of encumbrance over the assets of ZEE Limited and the loss that has been caused to ZEE Limited because of the circular and layered transactions masking the actual source of funds, while the entities are on the board of the companies under investigation. They can influence the direction and outcome of the investigation. The resultant irreparable loss that will be caused to the interest of the shareholders would be that the true facts would never come to light. The whole purpose of the enforcement action taken by SEBI will also become infructuous. To retaliate, the same is inimical not only to the shareholders of the companies involved in the present matter, but also to the investors' trust in the securities market as a whole. Considering the above, I am of the view that in order to prevent such an irreparable injury, the restraint imposed upon the entities has to be continued. Balance of convenience 97. For the determination of urgency for issuance of interim directions, balance of convenience needs to be assessed before passing an ex parte order. Whether the interest of the investors or orderly development of the securities market outweighs the affected interest of the person against whom the interim directions are issued. The factors for determination of balance of convenience can be manifold in a case. Such factors may be competing with the factors which contribute to the exercise of the no urgency. Each factor may have varying degrees of force for determination of urgency. The cumulative assessment of such factors would guide whether urgency or balance of convenience exists in a particular case. The essential principle for testing the balance of convenience in the present case would be to test if the direction is confirmed, what would be the probable inconvenience to the entities against whom such directions have been issued as a preventive measure in the interim vis-a-vis the inconvenience that would be caused to the investors and the market if the direction is not confirmed. In the given case, in view of the prima facie finding of misrepresentation and siphoning of funds, not only the investors of ZEE Limited are affected, but also market integrity as a whole and the investors' confidence in the market also get affected. On the other hand, the contrasting interest of the entities has to be considered who have been temporarily restrained from holding the position of director or key managerial position in select companies. I find it important to reiterate here that in the light of the egregious conduct on part of the entities as brought out in the interim order, it is essential that a fair, transparent and expeditious investigation is conducted in the matter so as to protect the interest of the public shareholders in listed companies. Considering the above, in my view, the balance of convenience lies in favor of continuance of the restraint against the entities till the time the proceedings in the present matter are complete. 98. Considering the above parameters and taking note of the fact that detailed investigation in the matter is ongoing, I am inclined to agree with the rationale that in order to carry out a fair and transparent investigation in the matter, it is essential that the entities are kept away from ZEE Limited's helm of affairs so that they do not adversely exercise their influence over relevant entities to misdirect the course of the investigation. 99. In continuation with the above, I note that entity number 2 has made a submission that since SEBI is asking for documents from him at this stage, even after passing of the interim order, the same shows that there was no urgency in passing of the interim order. With regard to the above, I note that the grounds for passing of the interim order have already been discussed in detail in the preceding paragraphs and the justification thereof is independent of the documents sought from entity number 2. Further, the requirement of seeking documents from entity number 2 arose from the submissions made by him post the interim order and also that investigation in the matter is ongoing as has been discussed in the interim order. The principles of natural justice would require that the other side be given fair opportunity for bringing out all its submissions in full. In case of gaps in the submissions, SEBI can ask the entities to furnish further information to substantiate their submissions. I therefore do not find merit in the submission of the entity number 2 in this regard and reject the same. Summary of findings. 100. To summarize the acts of omission and commission of the entities mentioned in the interim order which have led to the prima facie violation of the provisions of PFU-TP regulations and LODR regulations and my prima facie findings in that regard after consideration of the submissions made by the entities, I note the following. 100.1 LOC ensuring availability of fixed deposit of at least INR 200 crore with specific reference to ZEE Limited with Yes Bank was issued by entity number 1 on September 4th, 2018. The same has been prima facie found to be issued not in his personal capacity but in his capacity as chairman of SL Group, of which ZEE Limited is a flagship company. 100.2 By issuing the said LOC, entity number 1 effectively encumbered the assets of ZEE Limited to the extent of INR 200 crore. The said effective encumbrance became the reason for appropriation of the fixed deposit of INR 200 crore belonging to ZEE Limited by Yes Bank. 100.3 Though the LOC was issued for the loan taken by SL Green Mobility Limited, Yes Bank liquidated the fixed deposit of INR 200 crore towards the dues of 7 associate entities which are related parties of ZEE Limited. Further, entities number 1 and 2 along with their immediate family members are the majority shareholders in the said 7 entities. 100.4 as claimed by Yes Bank in its letter dated October 11, 2019, it decided to adjust the fixed deposit towards the dues of the 7 associated entities after having discussed with the leadership team of SL Group of Companies, both the entities being part of the promoter family and the position that they have held or are holding in various companies of the group or integral to the leadership team of SL Group of Companies. Please like the video, subscribe to the channel and share this information to all your friends who are investors in the equity market to know how the companies are utilizing your funds and whether your shares will have good value or not. Thanks for watching.